Good evening. We got a pretty full house, and glad to see all that is here. Got a full agenda. We're going to go ahead and get started. I'm going to ask J.P. Ecke, would you lead us in our prayer and pledge?
Thank you, Greg. Let's bow our heads in prayer. Heavenly Father, we're thankful for your word, and you said, acknowledge me in all your ways, and I'll direct your path. And we thank you that you do, and you guide us with the light from above. We ask your blessing on these proceedings, and may we always conduct ourselves worthy of your Son's name. Amen.
Amen.
I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so I need a motion to adopt the agenda. It's been moved by J.P. Madison, second by J.P. Harbison. All in favor? Those opposed? Adoption of the agenda has occurred. Preliminary motions. J.P. Madison.
Read all the ordinances and the Brentwood resolution by title only.
Second.
We have a motion to read resolutions by title only and all ordinances by title only. Been moved by J.P. Madison, second by J.P. Keeklat. All in favor? Those opposed?
No.
All right. At this point, we invite the public, our Washington County citizens, to come to and visit with us. Anything about the agenda, any other items that you would like to share, the floor is yours. Any public comments? Okay.
About public comments for 3 minutes?
That's correct.
It's why I came.
That's correct.
Right?
That's correct.
3 minutes?
3 minutes.
Okay, then I would like to proceed.
Come forward, share your name.
Fingers, please. My name is Yelena Buyalova. I used to be a resident of Washington County for a long time, way back. And I'm here actually regarding question of suffering from harassment, endless harassment from very bad official. I call him a dirty official. His name is Tim Hilder. If he's in the audience, I would call him, say that.
We just ask you to address us.
Well, it had to go to him because he is the one that's doing it. What your part is, which I don't support you as a judge either. I don't think you're equipped to be a judge. Why is my mugshot from 2014 is kept next to your clerk's desk since 2011? I mean, from 2011 is kept there for 7 years now. What's the reason for that? I've never met you. I've met Edwards. I was displeased because she would not make any attempts to remove him. If there is an official like him in the office year after year after year, and he harasses a single individual like me. I mean, 8 arrests through him and FPD that he had bad pursuits towards me to start with. This is not good for the county. You are not winning anything here. What you are sitting and talking about will be going to the drain, in my view, because I am harassed. To keep person for 5.5 months in jail because of false accusation is not right. Somebody of you, if you have a mouth and a tongue, should speak. I mean, I can repeat gossip about him that Mexican dancers are flown to him to dance in some barn and other officials involved. I've read about you that you could not even file the papers properly when you were running for the judge. So right here, right now, I would like for a different judge to replace you. Same with Hilder. I wanted it for a long time, starting 2007, when a psychotic Robin, sister of ex-husband, accused me of putting threat on the phone. She pulled in her daughter out of like some Mexican Artiga I've never met. I was prosecuted on felony, and it still harasses me on the web. There are comments when I was arrested through black neighbors who were urinating in front of me, throwing dirty piece of underwear on my porch, and I thought, what are they doing? We need to live by civil law. But each time I come and try to address you, it's like a knocking on a table or talking to graves. Where are you, all of you? I don't understand. I wanted for another person to come on my behalf, but he didn't. His child just committed suicide. It was a young teen. A spouse, he had cancer. So, but I addressed this person just like all of you. 1, 2, 3. How many of you are here? 15, 16? It's horrible what happened. I understand how short life is. I am asking you once again to look in the mirror. I wrote to the high office, very high office that does investigations for this country about all the case. It has to stop. Will you remove my picture from your clerk's desk?
Thank you very much. Appreciate that.
Will you remove my picture?
You come and visit with me, and we'll do that. Any other public comments? Any other public comments? Okay. Move to the approval of minutes. There's been a motion to approve the minutes. Second, approved by J.P. Madison, second by J.P. Dennis. All in favor? Those opposed? Okay. Resolution honoring the Moyer family. I think I saw them come in. Washington County 2018 Farm Family. I would ask J.P. Maxwell, you want to go ahead and invite them up?
Absolutely. Thank you, Judge. We'll just ask the Moyer family to come up to the lectern. Just like to say this is a great honor. We want to, I know we made the motion earlier to read all the resolutions, but this one by title only, so I'm going to ask our attorney if he would to read the full resolution for Washington County Farm Family of the Year.
Be it resolved by the Quorum Court of the County of Washington, State of Arkansas, a resolution to be entitled, a resolution honoring the Moyer family as the Washington County 2018 Farm Family of the Year. Whereas Jerry and Dana Moyer, along with their daughters, Cheyenne and Callie, have owned and operated a farm in Washington County for many years. And whereas the Moyer family currently farms more than 100 acres raising chickens and cattle in Lincoln, Arkansas. And whereas the hard work and dedication to the farming operations by the Moyer family has been met with great success. And whereas the Moyer family has been named the Washington County Farm Family of the Year for 2018. Now, therefore, be it resolved by the Quorum Court of Washington County, Arkansas, that Jerry and Dana Moyer, their daughters Cheyenne and Callie, are hereby honored and congratulated by the Washington County Quorum Court.
You're here.
We're very honored and humbled to represent agriculture in Washington County. Just a huge humbling experience.
And I'm assuming this is Miss Diana?
This is Miss Diana. Yeah.
All right. And did the other two, did Kaylee and Cheyenne and Kaylee come? No. Well, please extend our congratulations. We will have a resolution done. Everyone will sign that. We'll invite you to the courthouse and make sure we get you guys taken care of, picture, et cetera, and get that on the site.
Thank you.
Congratulations. Anything you want to share with us?
Just how honored we are.
Well, the county appreciates you. Congratulations. Please share that with your family.
Thank you.
Absolutely.
That's excellent. The county judge's report. Oh, resolution? Okay. I'm sorry. Been moved by J.P. Maxwell, second by J.P. Harbison. All in favor? Is this a roll call, Miss Patty? I'm sorry. Miss Patty, you want to take the roll?
Ann Harbison.
Yes.
Joe Kicklack.
Yes.
Tom Lindstrom.
Yes.
Eva Madison.
Yes.
Sue Madison. Joel Maxwell.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Usry.
Yes.
Daniel Balls.
Yes.
Harvey Bowman.
Yes.
Alicia Devins.
Yes.
Robert Dennis.
Yes.
Lisa Ecke.
Yes.
All righty. Judge report. In your packet, you should have the county disposal report. You should have the comptroller's report. Hopefully you got in a little early and was able to see some of the footage on the screens, some of the work that's going on in around the county and some of the bridges, Dye Creek Bridge, in particular Blue Springs Road there, the Blue Springs Bridge. Really excited about what's going on with Blue Springs, in particular all the bridges. Dye Creek is right on schedule, and again, we're looking to have that one open by Labor Day. I really think that we may be a little ahead of schedule, and so excited about where they are in Dye Creek. Blue Springs, again, was also slated to be open by Labor Day, and the way they have moved on there, I was out there, and we very well may be open before 4th of July. And so that's going to be really exciting with all the vacationers and people trying to get to the lakes and all. So real pleased with our road crew. We are probably now, County Road 108 is taken off. County Road, State Road 217 is done really well. We are probably 25 miles completed with our chip and seal program with a goal of 60 miles. So we're more than 35% through on accomplishing our goal and completing 60 miles of chip and seal. Wanted to share, we had a pretty bad accident last week. We had a bulldozer that was carrying a backhoe that was hit by a passenger truck, a pickup truck. It came across it looks like it came across the road and hit our truck. But in our move and attempt, it flipped the bulldozer, it flipped the backhoe. The guy went through his window, and one of our road crew guys heard it, turned around and came back to the scene, did some stop-the-bleed training on this individual, and helped save his life. By the time the paramedics came and got him sent over to the hospitals and all, he got shot. I mean, if you saw the pickup truck, you wouldn't even know how he even survived at all, let alone got through the windshield and got catapulted. But one of our road crew guys, who was a former fire department paramedics guy, he had gone through some of our training. We had all our road team go through the stop the bleed training. He came back to the scene quickly, heard all of that, and did some stop the bleeding until the paramedics got there and got him to the hospital, saved his citizen's life here in Washington County. So we're going to be recognizing David Williams, and many of you guys know David Williams. He's been around for a while, and Jerry Hunting's his son. So anyway, I just want to give that shout out to him, and if you see David, make sure you share your well wishes and congratulations to him doing something that we've trained all our road crew to do, some stop the bleeding because of something just like that. It does take some time for the paramedics and fire departments to get to some place, and if we can do something to stem the tide like stop the bleeding, it can save someone's life. So again, really appreciative of our team getting that training done and for them actually using the training. That's what it's all about. Animal shelter, just a quick update. The vicious dog we had, I guess it's been a couple of months now, the young Matthew Guest, who was mauled by the dog, sheriff, and we have deemed him as a dangerous dog. They appealed, came to the court. I ruled that it was a dangerous dog. It's still in our custody. They have appealed that to the circuit court now, and so we're still waiting in that particular case to see where that particular case goes. But right now, we still have that dog in our care at the animal shelter. Speaking of having the care, last week the Lincoln Animal Control or Lincoln Animal Control and the Lincoln Police Department and our Sheriff's Office served warrant on a Mrs. Kane, seized 72 dogs and some other animals, I think a few goats and one rabbit and a horse, I think it was. But anyway, the county is now has 25 of those dogs. All of the departments, Lincoln, the Sheriff's Office, the Animal Shelter, the Animal League, many the shelters and clinics are working, as this case is now in the circuit court. The prosecutors are working through that one, and we'll see where that one all particular lands. But that was a pretty harrowing, seeing that many dogs and getting them around and seeing everybody pull together that fast to get those dogs taken care of. So again, hats off to our Sheriff's Department, the Lincoln Police Department, and our animal shelter for taking care of that particular situation. Wanted to visit on our crisis stabilization unit, visit with you guys, I guess about a week ago at one of the committees. We have a place. It's been several months that we've been identifying a place. We started at Northwest Medical, then we looked at a place below the Free Health Clinic, Welcome Health, and then really for the past few months we were working on looking at the 5th floor of UAMS, and the talks went back and forth, and really appreciate the work of the county attorney, that the UAMS and the university systems executives really wanted to visit about this, and so we went and visited with them. At the end of the discussion, I think we all were real pleased with the outcome, which was a win-win. They really highlighted the fact that UAMS's future growth, they believe, is going to be up here, and that having that fifth floor will really help them. And if there was anything, if we really needed to have that crisis stabilization unit, they would not stop it because they really believe the need of this crisis stabilization unit. I said if we could go ahead and look at an alternate place, can we then look at some of the facilities that you're not using in our leases, et cetera? And they were very gracious to say absolutely. And so they'll be able to keep the fifth floor of the UAMS, continue with some of their future growth in years to come, while we will now look at the court annex as our place for the crisis stabilization unit. At the same time, sit down and start working through the leases and properties that they're not utilizing for the county and for county purposes. So it became a great win for everyone. Right now, we're working through cleanup, working through construction and design for the court annex. The RFQ for service provider, that's out. We should have a service provider who's going to manage the care at that crisis stabilization unit. We should have that done selected by July 6th is my target for that. The RFQ just went out, so July 6th we should have that entity selected who's going to be the service provider, and we should be then well on our way to opening up a crisis stabilization unit here. Yes, we'll probably be looking at coming to the court for some of the monies, but we are also working with some of the community who is saying we really want to have our hands and participate, and so it may not be the ask that we were thinking, and so we will keep you up to date as we move forward on that. But the big piece is that Northwest Arkansas will get a crisis stabilization unit. Real excited and pleased with our sheriff's department, who's been working with sheriff offices in the multiple counties, Carroll County, Benton County, Madison County, where they're sending their police officers to get the CIT training, which is crisis intervention training, because again, it's all going to be driven by law enforcement. If law enforcement is stopping and sees someone who is going through a mental or substance abuse crisis, they can make the determination, should they be going to jail or could they benefit by coming to the crisis stabilization unit, and that is where it's going to be driven, with obviously a good service provider to give them the ongoing support and help they need. So real excited about that. In fact, I was excited that Boone County has sent a couple of people to get through the training. So we may be picking up some additional counties. There's a need. Clearly, the counties around our area sees that, and we get a chance to go ahead and set an example of getting our crisis stabilization. So I'm real pleased with all the participants and Joe Maxwell, who's part of the committee and helping us work through some of that. Lastly, I wanted to say we have one action item. County Library Systems, the Washington County Library Systems kicked off their summer reading program. I'm big with that, so if you got little young ones, get them out there, see some of the programs in our various counties, county libraries. We did have a vacant seat come open on the board, so I have a name, Ms. Jane Bryant out of West Fork, and I would need your support on the nomination. So Jane Bryant out of West Fork being placed on the Washington County Library Board.
I move we place Jane Bryant on the Washington County Library Board.
I've got a motion. I got a second. All in favor? Aye. Those opposed? All right. That's what we have in our judge's report. We'll move on. Number 9, ordinance appropriating the amount of $8,600. Would that be J.P. Ussery?
An ordinance appropriating the amount of $8,606 from the general fund to the county attorney budget for 2018.
Okay, this is the last reading of this, and we've gone through and we've talked about it at length, and I think particularly it's one of those, it's kind of a prickly pear, but I think that we've got some information tonight in our packet here that was prepared by Mr. Johansson. I think it helps to maybe clarify this just a little bit. And so having said that, we're open to discussion. Thank you.
J.P. Madison.
I wanted to, there's not a motion on the floor, but I felt like it was important to prorate the amount. We've been considering it, and we always prorate salaries when we give increases. And so if it would be effective next month, I think it should be reduced by 50%. So I would ask Mr. Ussery to entertain a motion to amend the ordinance to reduce it by half to prorate it for being a raise for the remainder of the year. I mean, I don't know that we ever give raises retroactively. If we give a raise, we give it prospectively.
Well, I understand that. I also understand we've been kicking this can down the road for quite some time. And I think that, and particularly in light of how this whole thing came about, I'm not inclined to do that at this point. I mean, I'm open to discussion, but I think because of the way that all this transpired, I think it should be from the beginning of the year.
J.P. Bowman.
Thank you, Judge. I'd like to hear from our advisor about personnel issues. Could you come and share with us about this?
Mr. Johansson, sure.
Thank you, Mr. Chair. You've got a couple documents that have been provided to reference, and I think this will be helpful in being able to establish or understand what would be a competitive rate or rate structure, range structure for the county attorney. I'll reference the document that's Market Pay Study, June 2018, Position County Attorney. What we wanted to do is provide you documentation that represents salary information at the county level, so a similar county like Pulaski County, Class 7. Benton County is not included because they outsource their legal services. And then also cities representing Northwest Arkansas and the state. And then also the Department of Labor data that provides us information on all attorneys, both public and private sector, both throughout the state and also Northwest Arkansas. So if you don't mind, I'll just walk through this table and then provide a understanding of how we come up with a recommended salary structure. There's a couple options there. So Pulaski County County Attorney, there's one, and the salary $96,895. The Northwest Arkansas major cities, there's 4: Bentonville, Fayetteville, Rogers, and Springdale. There's 4 attorneys. The average is $122,538. The Arkansas Municipal League, we have, and that represents the other document that provides the most recent study from the Municipal League. They complete that each year. What you have in that page is all of the cities that provided documentation on the salaries for their city attorney. And so we broke that up into 2 groupings. One would be all the cities representing 45,000 plus population, which would represent the cities primarily in Northwest Arkansas, and then 3 other cities. The average is 118,607. And then if you look at all the cities where there's 31 reported city attorneys, the average is 94,367. And then the next grouping of data is the Department of Labor, and that's broken into 2 different subsections. The first subsection, you'll see where it says Northwest Arkansas or NWA. So, and they provide a pay mean, which is an average, or pay median, which collapses to the middle. So on the pay mean for 600 attorneys for Northwest Arkansas, it's $138,580. And on the pay median, when you collapse to the middle, it's $92,331. And then the next grouping is for the state of Arkansas. So we're also providing that as a reference for 2,730 attorneys, pay mean 99,100, and then the pay median 84,282. So to give you a comprehensive value, if you will, for the pay average for the state and Northwest Arkansas, it's 105,838, representing the pay average. And then if you build a pay structure, typically the way we look at a pay structure in the county mirrors this, with 80% of a midpoint representing the minimum and 120% the maximum. Then a proposed range structure based on the market average of 105,838 would be 84,670 for the minimum, $105,838 would be your midpoint, and your maximum $127,006. Now, one other option here, which is that lower grouping, is if you were going to build your pay structure based on the Northwest Arkansas median, and you'll see where it's highlighted out to the right, then that would take your midpoint from $105,838 to a midpoint of $92,331. And if you build your structure off of that midpoint, then your minimum would be $73,865, midpoint $92,331, and the maximum $110,797. So you really have two options: one, building off of the market average mean, or building off of the median for 600 attorneys in Northwest Arkansas at $92,331. Now, based on county policy, each elected official, based on your salary policy, can bring in a candidate if they have experience that exceeds the minimum for the position job description, up to halfway between minimum and midpoint. So if you use the $92,331 value as your midpoint, use that as your range structure, and with the county attorney having 11 years of experience, and the job description requires a minimum of 5 years, so it will exceed, then the elected official has the latitude to bring in the county attorney at $83,098, which would exceed where we are on what's being recommended. So this is a good way to build a structure based on market, since it's not a position that we value, job rating value in the market. And so historically, we've gone to the market to look at the county attorney and also to look at the IT director. Both positions that are not valued through the rating system. So that's the report I had.
Excellent, excellent. J.P. Bowman and then J.P. Madison.
I make a motion that we pass 9.1.
Got a motion and a second. Before we take the vote, J.P. Madison.
So this position was evaluated back in 2016, and so I'm confused as to how, if we took every employee in the county and gave, I think there was someone in the library that got like a 17% raise because of the market research that you all did, why this didn't get brought to our attention, because the county attorney was given a very minimal increase. And so I'm concerned about that, because we were led to believe that was the market, which has been a large part of my opposition to this, was that it was set at the market in 2016.
Right. So those two positions, the county attorney and the IT director, were excluded from those adjustments because they were not part of the job rating system. So I believe their adjustments were just based on the minimum of what was recommended for the whole group. And I think that was probably somewhere around maybe 3% or 5%. 5%.
It was 5, yeah.
So I think it was associated with the general 5% at the bottom of the schedule.
Well, I remember somebody telling us that Mr. Zago was being paid more because of his 20 years experience. Where did that come from?
I don't know that. Again, for those two positions, it's really based on market and based on experience.
Okay, that's certainly puzzling. So do you know of, in our history of giving retroactive raises in all your experience at the county?
The county has done that in the past.
Do you know for what reasons we've done it?
No, not top of mind. I just know that that's been done in the past.
Okay. Okay, thank you.
J.P. Pine, did you have a question? No. We got a motion. J.P. Madison.
Thank you, Mr. Judge. I would just like to raise sort of a soft objection to the language in the ordinance where it says it was incorrectly omitted, because I don't know that that's really been substantiated, and it appears to me to be a little bit of editorializing. We had lots of budget meetings. We looked at lots of issues in the budget, and to say that there was an $8,000 oversight that we all missed is, I think, editorializing, and it bothers me that that's in an ordinance.
J.P. Ecke.
Thank you, Mr. Judge. Okay. I'm okay. Thank you, J.P. Pond, for making sure that I'm set and ready to go. That's okay. No, that's fine. To Ms. Madison's point, in the budget process, we did look at it, but however, it was incorrectly omitted the way I see it, because did you not, Judge, submit your budget and it was incorrectly omitted from that process? And so I believe we've already chased this issue around the mulberry bush several times, and it was, for the most part, at least in my mindset, concluded that it was an error on our former comptroller's part, and the motives of whatever they did was, I can't address because I really don't know why they did what they did, but it was incorrectly omitted because the judge submitted his budget correctly, and they're the ones who incorrectly omitted it. Am I connecting the dots?
That's exactly right.
And so, I mean, we've had that discussion, but to your point, that's what I see, and I'm glad you raised it, so that way perhaps we can stop chasing this one around and around and around. Thank you, sir.
J.P. Balls.
Thank you, Judge. Yes, I remember those conversations. I also remember that the county attorney had signed off on his budget. What gives me pause on this is money for travel, trips to D.C., that money was made sure that those line items were done correctly, but the salary wasn't. And also look at, if this was going to be given, this would have come before us as the Finance Committee because the raise was going to be so significant from where it was previously. So really what we're doing is having this conversation after the fact. And so if we want to go on ahead and give it, that's okay, but I'm with J.P. Madison. This was not incorrectly omitted. We can only go with the information we're given, and that comes from the department heads. Yes, it was not added to that, but we got it with the blessing of the county attorney that it was right. And so I've got some pause on this, and I will think he probably is underpaid. I think he probably are underpaid, Mr. Lester, but so are most county employees. And if we're willing to give one county employee an $8,600 raise, we need to be ready to give that to a lot of other county employees. So that's where I stand. Thank you, Judge. Appreciate it.
Anyone else? Any other comment? We have a motion by J.P. Bowman and the second by, who's that? By J.P. Ussery. Public comments? Public comments? Thank you, brother, Mr. Johansson. County Attorney Lester and then J.P. Harbison.
To your point, Daniel, this was not given with my blessing. My budget wasn't taken up in the schedule that it was given. It was taken up out of order, and I was not here and had no notification. So it wasn't given with my blessing. This was a market increase to this position that was passed by this court in 2016. This is not a raise. I'm glad that that's what Scarlett has been happy to put in the paper every single time because it fits the narratives of those that don't want it. This is not a raise. This was going back to the market value of what was presented and voted on by you in 2016. Yes, the budget was submitted correctly to the comptroller. She admitted when she was here that she changed it because she didn't understand why that would be that way. She didn't ask anybody's permission. So this is my public comment that it's not a raise, that it was not done with my blessing, and I wish that that would stop being what's said because that...
He's making a citizen comment that needs to be outside of his role as county attorney. I think we're...
Okay, all right. J.P. Harbison.
He's out of order.
You don't make that decision.
J.P. Harbison.
That's okay.
J.P.
I just want to make a comment that I will be voting for this because the judge made the recommendation. It got changed. We never got it. So therefore, I think we need to correct a wrong done. So, and this doesn't have to do with Lester as the attorney. It has to do with any attorney or any position that we have an incorrection. So therefore, I'm going to be supporting this. Thank you.
Any other public comments? Oh, J.P. Pine.
I'm interested in knowing, because he was asked to speak, does Mr. Lester have anything else to add?
I do not.
Okay, thank you.
Thank you, J.P. Pine. We got a motion, a second. All in, we got a roll call. Ms. Patty?
Ann Harbison.
Yes.
Joe Kicklack.
No.
Tom Lundstrom.
No.
Eva Madison.
No.
Sue Madison.
No.
Joel Maxwell.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Usry.
Yes.
Daniel Balls. Harvey Bowman.
Yes.
Alicia Devins.
Yes.
Robert Dennis.
Yes.
Lisa Ecke.
Yes.
All right. Item 10, J.P. Harbison. What was the final, Ms. Patty?
8-6.
Okay. Ms. J.P. Harbison. Item 10.
Pass.
Emergency ordinance ratifying a conditional use permit read by the Planning and Zoning Board, White River Landing.
Read that by the title.
My,
You read it by the title.
Here.
what?
Oh. You have.
Okay, I'm going to make a motion that we go on and pass this, and let me give the reasoning behind this. We had two attorneys' opinions. I asked for the Association of Counties to give us an opinion on it, and now we have a Mr. Davis opinion, and the opinions are about the same, that they probably we cannot turn this around. I still believe that the property is too small for what they want to use it for. But I also know that I don't want to spend the county's taxpayers' money on something that we cannot overturn. And I don't think that this can be overturned. And I feel for the neighbors down there. I hope that we'll be good neighbors to each other and try to work some of these things out on parking and those kinds of things. But that's my position. So I move that this be passed.
We got a move by J.P. Harbison and a second by J.P. Pine. Discussion. J.P. Madison.
I'm not sure J.P. Harbison read the same letter I did. The letter I got from Connie Clark, a woman, suggests that we could prevail on appeal. If you read the letter that was presented to us, the opinion that presumably Mr. Lester obtained, because it's written to him, which is consistent with some of the feedback I received, that it's not a perfect appeal, but certainly there's room for argument. And I feel like given the importance of the issue at stake and the standards that were applied, I'm not sure. It specifically says it's always difficult to put a percentage number on the likelihood of success in appeal, as it is impossible to predict how an appellate court will view a case. However, I think we can make a very persuasive, good faith argument that there was indeed substantial evidence to support the decision of the Quorum Court, that there were genuine issues of material fact as to whether Mr. Presley's application met the criteria for granting a CUP, and that the court therefore erred in granting summary judgment in favor of Mr. Presley. So I think perhaps we should pursue with the appeal that we already filed. So thank you, Judge.
J.P. Patterson.
Thank you, Judge. The issue I have is I think we were supposed to make this decision whether we're going to vote it up or vote it down. And we've talked about it long enough. I think we should just vote. Because if we just pass this off to the committee that is under us, we're not actually following the law the way I see it. We're supposed to make that decision because we're elected. And so that's all I want to say. Thank you.
J.P. Patterson, thank you. J.P. Balls.
Thank you, Judge. So I guess do we need to pass this, or do we need to vote to appeal this? And this is probably going to be a question for Mr. Lester. What happens if we just don't vote to approve it? So I guess I got two questions. Do we want to appeal it, or do we want to vote on it? And if we decide that we're not going to pass it, what would happen?
Well, you've already voted to appeal, so that process is in works. If you were to vote to pass the CUP, the motion that's on the table, then that would end effectively, it would end your appeal. There would be no need to appeal it if you pass the CUP. The way I look at it, that would be a vote to not go forward with the appeal, to grant the CUP and to move on. If you don't pass this, then the appeal is still moving forward. And if you, unless you vote to stop the appeal, and if that is the case, then you've been given a directive from the circuit court that you must issue the CUP. I guess technically, I won't get into it, but yeah, I guess there could be a contempt action if the court decided not to do that. What that looks like, I don't know.
J.P. Bowman.
Thank you, Judge. I'd like to hear Mr. Lester's introspection of what this all means, the letters and your personal opinion.
Well, I think both attorneys have stated the thing about appeals, just like pretty much any lawsuit you file, nothing's a guarantee in the law for the most part. I mean, there are some cases that are much stronger than others. I think both of the attorneys here have indicated that, Mr. Whitmore was a little bit more forward with saying, hey, I don't think that this has much of a chance. Connie Clark, Ms. Clark, who I have the utmost respect for, is a great appellate attorney. That's all she does. I've read this letter, but I also have emails from her as well, back and forth, and she too recognizes that this isn't a guarantee. It may be kind of an uphill battle, but nonetheless one that she has clearly maintained in this letter, that appealing this, you're going to put forth a good faith effort. In other words, we're not just going to go up there and appeal for the purpose of appealing. There are arguments to be made. There are things to appeal. The way she looked at it is, while one standard was applied, the judge utilized one standard. The judge mentioned another standard in part of the judge's ruling. The way that Ms. Clark sees this is the affidavits that were presented were nothing more than the evidence that was presented at the hearing, which was true because Nathan Crouch presented the same information in his affidavit that he presented to this hearing. While the judge said that you didn't meet proof with proof, she said, basically there was proof because all of you stated that went out there, we went there, we looked at it, this is our proof, and that's proof. The judge discredited that proof in his ruling and said going out there and looking at it isn't the proof that I guess that particular judge thought was appropriate, and so said that he didn't feel that that was proof. But Ms. Clark recognizes that no, that isn't. She agrees with you, that is proof. As much as Mr. Couch's testimony, Nathan's testimony was proof, so was your opinions and thoughts, because you did something more than just sit here and say no. You actually went out and made an effort. So I leave it up to the experts, and I think that Ms. Clark says that she thinks that there is some good points on appeal. Other than that, it's not really my decision at this point.
Okay. Next question would be, if we go ahead and decide to continue with the appeal and not pass this, who would represent us in that case?
Connie Clark.
All right. And then next, what kind of money are we talking about to have this going through the appeal?
We have signed an engagement letter. Her hourly rate is $250 an hour. And that's for her hourly rate, and which is, I think, a fair rate given the amount of experience she has. She's been practicing law probably 20, 30 years, quite a long time, and is well respected. And so I think that's a fair rate, the $250 an hour. And then, depending upon whom she uses in her firm, there could be, a clerk or an associate attorney, and I think they bill out at about $200 an hour. And then any costs, your normal costs associated with that. How much, I couldn't say.
Well, I really hate to think about us being the decision we made being overturned, because I think it sets a precedent that we'll have to deal with for a long time to come. And I don't know if we're going to appeal. I hope that we'll build a very thorough case and go after them like a bad dog with this situation, because it's just I just feel like the judge is trying to create law from the bench, and I just really resent that, and I just think it's something we need to try to buckle up to and do the best we can to beat this thing. Thank you, Judge.
J.P. Devins and then J.P. Madison. Was it J.P. Dennis?
I was
Devins?
yielding to. I was pointing to Ms.
You were
Madison.
yielding?
She
Okay.
did not get it.
All right. J.P. Dennis, then J.P. Madison. Okay.
Thank you, Judge. I was right along the same line as Harvey there. I was curious about cost. $250 an hour doesn't tell me what it's going to cost. That tells me what the charge per hour. So how many hours could this possibly be?
Sure.
How, what's the max? Not what's the minimum, but what's the max that this is going to cost? An average. Give me an average, because I see it costing $20,000 and try 60,000. My neighbor says. So 20 won't cover it either. So I don't know. So there we got 20, and there we got 60. So what do you think that it will cost then?
I think an average is going to be in the $30,000 to $40,000 range, just an average. I mean, there's a lot of factors that go into whether that goes up or down, but
Right.
I think that
I understand that.
$30,000 to $40,000 is probably what you're looking at.
Well, speaking for my constituents, I can't speak for other constituents, but based on the facts that I talk to a lot of people before I make a decision, and they don't want to spend the money, and so I'll be voting against appealing, however you want to word the motion, but I don't think we need to go and appeal this. Thank you.
J.P. Madison.
Thank you, Mr. Judge. I want to point out that toward the bottom of the first page of the letter, she points out that the court is to give the light most favorable to the county. I mean, if the court has a bias going in, they're obligated to favor us, which I found to be very encouraging. And the fact that they used the arbitrary and capricious argument in the wrong kind of decision, and the fact that they really did ignore most of everything all of us said the night we considered that. J.P. Bowman went to the planning board hearing and told us there was, some angst among the members in passing that. J.P. Ecke went and did a lot of research on this issue. The planning staff that was here that night pointed out that they'd never had a wedding venue on such a small parcel of land out in the county. The proximity to the neighbors was a big issue. And the fact that it was a small rural dirt road with long-time neighbors there that were kind of used to their way of life, that this was, come certain Saturdays, going to have a major effect on their lives. And I think if it were Mr. Dennis's constituents that were in this situation, he would want us to be supportive of them. And this is not my district, and I doubt there'll ever be a wedding venue that the county approves in my district. But I think we owe it to the people of Washington County that have come to have some confidence in the kind of land use planning that goes on around them. And this sort of shattered the confidence of those people. And I don't know how we put a dollar figure on that. I mean, it's difficult to live out in the county sometimes. Law enforcement's a long way away. Emergency services are a long way away. You make some sacrifices by living in the county, but you get the trade-off of some peace and quiet, wonderful neighbors, things like that. And I feel very strongly that we owe it to the neighbors to see this through. That judge may have been having a bad day.
J.P. Pine.
Thank you.
Thank you, J.P. Madison. J.P. Pine.
I want to try and keep it in mind that the part of the process after that leaves us. We voted, we turned this development down. Yes, we did. But part of the next step in that is if a person so chooses, they may take this to circuit court and appeal. And I keep hearing that this sets a precedent that if we let this go, we just don't have any clout at all. Well, now, if that's the case, then we must have expected that any time anyone appealed this to circuit court, that judge would just, he'd decide with us. I just don't believe that because I've been called capricious and, amongst some other things here, which I didn't become really indignant about it when it happened. But I don't, even this very same judge doesn't necessarily, next time one of these comes before him, decides I'm capricious next time. I don't see that. I don't think we need to be eliminating a step in this process. I don't think we need to decide that the judiciary branch of our government never gets any kind of opinion or say so. He might disagree with me. I very honestly had reasons why I had reservations with this. But that doesn't mean I'm going to close my ears to any kind of constructive criticism. Now, as far as some light most favorable on our part, if we carry on with this, I got to consider the source, and it's not got anything to do with this lady that I really don't know, that she's ready to go to battle for us for $250 an hour plus, but that's got something to do with maybe her seeing light in our favor, and I have to take that into account. And then we got this idea of this small parcel of land. Sometimes people don't realize how much land 1 or 2 acres is, let alone this. It's a pretty sizable amount of land, 1 acre is. The most complaints we've had about this, including the ones we made ourselves, they have to do with what we're afraid might happen. These folks hadn't done anything at all to offend anyone. They've got an idea of something they wanted to do. I might not think it's a very good idea, but sometime, somewhere or other, people that own a piece of property need to have some reasonable chance to do what they please and still try to be good neighbors with their property, as long as they're not disturbing or offending someone else. We're just afraid they might. They've not done anything. I drove by there the other day. The place is kind of in a shamble right now because they had to stop what they were doing. Instead of a nice circle driveway, there's a pile of gravel there with a bunch of weeds growing up around it. And I feel a little bit guilty about that. We've shut them down. I really just don't believe we need to take Washington County tax money and use it in court to fight another government entity that's costing the state and county tax money. We're going to be spending tax money to fight somebody that's taking tax money to fight us. And we don't know how that's going to come out. I really don't think, there is a court of appeals that this could go to, but sometime or other, some of the folks in that neighborhood that really don't want this to go in, maybe it's their place to take up the ball, not the taxpayers of Washington County. I'm just obviously I'm gonna vote to pass this along and let these folks prove to that neighborhood that they can be good neighbors. Thank you.
Thank you, J.P. Pine. J.P. Lundstrom. J.P. Madison, J.P. Lundstrom. Did I call you? Yeah, all right, J.P. Madison.
Beauty. Wow. Thank you so much, J.P. Lundstrom. I'll remember that one. I would say that Ms. Clark giving us a rate of $250 an hour is a gift. She's a very experienced, very good attorney. That's very discounted. So she is giving us a break. And I've handled several appeals to the Court of Appeals, to the Supreme Court. I can't imagine that it could cost as much as $40,000. 80 hours. Just think about what 80 hours of her time would be. That would be 2 solid weeks of Ms. Clark, and without the assistance of a junior attorney working at a higher rate, 80 hours would be $20,000. That's a lot of time. This is a very neat record. It's simple. It's not going to be a complicated appeal brief. So I think that $250 an hour or $20,000 is a small price to pay for what's at stake, because this is what people pay taxes for. This is what people give their money to Washington County to do, to protect the land, to enforce zoning regulations, to protect the way of life in the county. I mean, most of these people sitting out here are the people that are affected by this, and they have come time and time again to all of these meetings to let it be known that there are people involved in this. And I've said this before, but I'll say it again, because if this decision stands, it will be cited at every future planning appeal that we have to rely on professional advice to base our decisions, and that the things that we look at, compatibility with the surrounding area, proximity to the river, things like that, that we can't consider those kind of things, that we have to follow planning staff. And I feel like we are elected to do a legislative job. This is supposed to be a legislative duty. It's not supposed to be delegated to staff or engineers. And so if we're doing our jobs, we have to defend this principle. We have to. And I think that's a small price to pay for what's at stake. So I believe because J.P. Harbison, it's her district, she should withdraw her motion and we should proceed with the appeal. It is her district. It's her folks that are out here. She's been very passionate, I know, very involved with this. The appeal's filed. We've got a lawyer ready to take it at a good rate who's telling us she thinks we've got a good chance to put forth a good appeal. And that's what we should do. We've got to defend the principle of we are the legislative branch. This is a legislative decision, and we shouldn't be called arbitrary and capricious for doing our jobs. Thank you, Judge.
J.P. Lundstrom.
Judge, can I have a minute?
Well, we'll get to public.
I remember very distinctly the night we dealt with this situation, and every one of us was required to give a reason for our vote. And every one of us had a reason for voting against this conditional use permit, such as the building was 10 feet or less from the property line, which doesn't meet county requirements. The river was very close. The parking, there were just a number of different issues, the dirt road, etc. And there were some requests for that to be chip and sealed and so forth later anyway. But I agree with J.P. Madison. I don't anticipate anywhere near that kind of a cost on this. I may get fooled, but I don't think this is going to take very long. But the judge needs to listen to the proof that we gave, which he didn't. He just judged it to be capricious, and that was the end of it. So I think we've got a very strong case for an appellate court, and we should win it. But I'm like J.P. Bowman. I'll get it right here. I'd be like J.P. Bowman. I liked it when the planning board made the decision, and that was the end of it. And then the state government, in their wisdom, said, no, now you have to start making these decisions. Well, you know, if our decision doesn't mean anything, why make it? Just let the circuit courts make it. You know, give them the dirty job. So I'm with Eva. I think we need to appeal this thing and win it and get the confidence of the people back in this court on these issues rather than in the circuit court. Thank you, Mr. Chair.
J.P. Maxwell.
Okay. Thank you, Judge. There's probably 3 or 4 things in this that I think come to mind for me, and I will say I was able to talk to all the folks involved in this when this came up, but I was not here for the vote, so I was the absent member that evening. But I know how I would have voted and know how I plan to vote this evening. But there's a couple of things about this that I think bear noting. One is, and I've heard all the details about how far away from certain things, et cetera, but at the end of it, our planning and zoning laws and rules and committee did pass Mr. Presley's request, and I think he met all of their requirements, if I understand right. Every time that something additional was asked, he did meet that. So if we have some issues with the rules around what can be built and what setbacks are or whatever, I think perhaps those are something we need to deal with on a planning and zoning ordinance side. I also agree with J.P. Dennis where planning and zoning said yes. The property owner said yes. We said no, but then the judge said yes. And I feel like if we're not careful, we're going to get another yes before we're done with this, but it's just going to be expensive, and we're going to be told for an additional fee, 20 or 30 or 40, whatever thousand that is, plus, you know, however much time we've spent on it and the Planning and Zoning Commission or committee has spent on it. But it does seem like we're getting a prevalence of yeses to Mr. Presley's request. And I think the next no on our part is going to be very expensive and may turn into a yes very quickly. The most important thing to me, though, is Mr. Presley purchased the land. He's a county resident as well. And while there's only one of him and several neighbors, by definition, that's just the way it works. I think we have to be very, very careful about how we decide what someone who's purchased a piece of property gets to do with that piece of property. I have some of the most wonderful neighbors in the world. They run a very large garden. They're the hardest working people I know. And they sell at the farmer's market their produce. But about 3 times a year they decide to fertilize their garden with animal litter, and the prevailing southwest wind comes straight to my house. And I can tell you I don't really appreciate that, but I understand that's their property, and that's just part of being a neighbor in the rural part of the county. That's part of agriculture in that case. And so there are times I know we don't always like what our neighbors may do. And if it ever gets to the point where it's so egregious that it breaks a law, and I think if this did, I think that judge would have looked at the law and said, this is offending the neighbors to the point where the property owner doesn't really have the right to do that. And I wasn't there for his ruling, but I'm assuming the reason he called it arbitrary is because he's going by the word of the law, and we go by the approach of the citizens in the county, our feelings, and it's a little more of a subjective thing. But I think every time it's been an objective thing, Mr. Presley, whether it's planning and zoning or the judge or whatever, has been granted the right, at least at that moment, to do what a property owner has the right to do, and that's use his property. Last thing I'll say is this. I think we also have to remind ourselves that this is not as simple as do we grant him the wedding venue or not, because in the event that Mr. Presley doesn't get access to have a wedding venue, it's very possible that he could open up some rental dwellings, lots of other options. I think we have one right now going on where someone's decided to open a goat and hog farm in lieu of what they asked for. So just because we say no to this doesn't mean that Mr. Presley might not do something else that's perfectly legal there that would also offend the neighbors. Again, much like my neighbor, and I put it in quotes, offends me about 3 times a year with the way they fertilize their garden. So it may not be as simple as if we rule no that there's no extra traffic, there's no extra buildings, there's no extra people, there's no extra activity in that part of the county. It may not be quite that simple. So I appreciate your time. I'll be voting for Mrs. Harbison's emergency ordinance because I think that is probably the wisest thing to do after we've checked out all of our venues. And I think it also honors the property rights and the Planning and Zoning Commission's approach. Thank you, Mr. Judge.
J.P. Maxwell, thank you. J.P. Harbison, and then J.P. Bowman.
This is a very difficult decision. And I read the letter from Ms. Clark, and I read the letter from the Association of Counties attorney. The Association of Counties was pretty strong against that we would prevail if we appeal this. He did not think we would. Ms. Clark apparently is very cautious about what she's saying, that maybe we can and maybe we can't. And I think at this point, we've got we've got attorneys speaking, and attorneys speak very well on their subjects, and they always want to go forward. And what I'm trying to determine is to cut away everything and get to the meat of the problem and determine if we can win this case by what's been presented by the Association of Counties and what's been presented here in this letter. She gave some ideas that we might prevail. And I don't think it's strong enough for me to change my mind to vote for the appeal. Anyway, that's my position. I still think the property's too small, but also this is, and I think Eva is right on this, that we're setting something that we may not want to live with later. But at this point, I don't think we have any choice. I don't want to waste the taxpayers' money. I feel for the neighbors and their opinions, but I'm pretty straightforward about how I feel about it, and I've made my decision. Thank you.
Thank you, J.P. Harbison. J.P. Bowman, and then J.P. Ecke, did you have a comment? Okay, J.P. Bowman.
Thank you, Judge. One thing here has been completely omitted from this discussion. The zoning laws are out there for a reason. And the Presleys bought this property knowing exactly how that property is zoned. And they have to deal with the reality of that. Now, the neighbors, they may decide to go ahead and put a hog farm within 10 feet of their wedding venue. And you know what? If I was out there and imposed this like this, I might do that. But I think they'll find their business is pretty slack once they have that kind of neighbor within 10 feet of their property. And I think they've got to deal with that reality. But, I think that's a basic fact that we got to say, if we're going to have zoning laws, is it not stupid to ignore them? And that's basically what's happening. And maybe we need to put some more teeth in the Planning Commission's quiver to go ahead and deal with some of these kind of things. But either we got zoning laws or we ignore zoning laws. We got to make up our mind which way we're going to have it. And the Presleys bought that property knowing full well how it was zoned. So that's what I'm basing my opinion on. Thank you.
Go ahead, Connie, sir.
I just want to point something out because it's come up in discussion. It has nothing to do with the vote. The Quorum Court is not required to sit as an administrative appeal on these decisions. You have the right to vote to not do that, which would say any appeal by the planning board's decision would go directly to the circuit court. And I just want to point that out to you. Under Arkansas law, you don't have to sit as this appeal board. You can just let it all go up to the circuit court for what it's worth.
J.P. Ecke.
Thank you, Mr. Judge. I am teetering and tottering on this in this respect, and I appreciate my fellow JP's input, insight, professional advice. And this is where I am. How much is it going to cost? I'm a very bottom line person. I want to know how much is this going to cost us to appeal this. And I go back to Springdale and I hear, I thought you were pro-business. I thought, and I am, and yet I'm taking away the property rights of this man to do with his property what he wants. So I'm trying to balance this out. How much is it going to cost? Well, if it's going to cost $20,000, $40,000, I'm thinking, well, heck, why don't we support the 4-H, which is the future of Washington County? And I heard an amen. Then I think employee raises, he gets to do what he wants, and yet I was not arbitrary and capricious in my research before I did this. What I think when I asked him, do you have a business plan, that has nothing to do with whether or not they will be granted or denied a CUP. How well prepared they are for business, if they know they have a Mack truck coming at them 100 miles an hour, that's none of my business. I had these parameters to vote, 1, 2, 3, 4, 5, 6, 7. And did I agree or did I disagree? This is tough. I'm an American, I'm a patriot, and you have property, it's your property, you get to do with what you feel is right within the confines of the law. I agree with J.P. Bowman, J.P. Maxwell, J.P. Madison, so I am here trying to weigh this out, and I just wanted to let you all know this is not easy, because then I heard those property owners saying, what about our property rights? We've been out here for 26 years. And my way of life is going to change because of this one person. You got to weigh it out. And I guess that's where I am. I don't know, but I don't like spending money if you don't have to. Unless you're going to support the 4-H. Anyway, thank you, Mr. Judge.
Thank you, J.P. Ecke. Any other comments? J.P. Bond.
About that money spending thing, it's been mentioned several times here. What the discussion here is about is, do we take a gamble on spending some more county tax money on something that who knows what the decision's going to be at the next higher court? Or you could take the same amount of money and do a little bit to improve that road out there in that neighborhood that's badly needed, whether there's a wedding venue there or not. We keep, and that's another thing. That's money that's going to be dipped from funds that basically would be taken away from more road improvements. A lot of people don't want to look at it that way. They think, well, the county's getting smaller. They need less road improvements. I happen to disagree with that. The busier this county gets, the more road improvements we need, more road maintenance we need, smaller amount of real estate, but more traffic. I just think we're taking a gamble with some tax money that could be used for something constructive, whether it's roads or 4-H or whatever it is, something that will have a positive effect instead of fighting our judiciary branch of government. Thank you.
Thank you, J.P. Pond. Public comments.
Yes, sir. Just wondering, has the quorum seen the minutes?
Come on, sit down, state your name, let us know who you are, and then we can hear you. Is the mic on? Yes.
Yes, sir.
All right.
I was wondering if the quorum got the chance to look at the...
State your name.
Sorry. Terry Presley.
All right.
I was wondering if the quorum had saw the Greenland Planning Commission minutes. I went to the Greenland Planning Commission with this a couple of weeks ago, and here's the minutes for the Planning Commission. Would you like to pass it around? I'm sorry? Can we pass it around? Doesn't matter?
Sure. Go ahead. Go ahead.
I mean, I just folded it to this page.
Oh, you only have one? Well, yeah. Yes.
All right, so it's item 2, and it's White River Landing, LSD, large-scale development. Does the Planning Commission have any problems with this type of facility? Commissioner Guthrie, no. Bill Yos, no. Paula Chauvner, no. Brenda Reynolds, no. Charlotte Carnes, no.
That's the Greenland.
Yes, sir. Yeah, went to the Greenland Planning Commission a few weeks back to see what their thoughts were on it, and they voted, I guess, 5-0 in favor of it.
Okay.
But I'd like to just address a couple of things. The Mr. Lundstrom pointed out about it being too close. I actually had to pay for a surveyor, and that's in the documentation where I was beyond the county's guidelines. The county's guidelines is 10 feet. I'm beyond that in the documents that a surveyor prepared. I mean, the full-time paid professional staff recommended approval. The county, I mean, I don't understand how it got this far. I really don't. I mean, your paid professionals recommended approval. I met all the requirements laid out by the county. County Planning Committee voted to approve it. A circuit court judge has said that I should be issued a permit. The Association of County Attorneys has also said that they think that you wouldn't prevail in an appeal. I guess for enough money, if the county wants to spend enough money, they can find an attorney maybe that will hopefully win. But I mean, I think it just seemed like this went way too far. I appreciate your comments, J.P. Maxwell. I think it was very put together. I wish I was as eloquently spoken as some on the court, but is there any questions? I mean, while we're here, I mean, one thing I'd want to point out. Another thing is you keep bringing up that the property's too small. Well, this court approved a wedding venue on 3.9 acres, nearly half of what mine is. Out on Haberton Road. I think it was in April last year. Is there anybody familiar with that? Nobody's familiar with that? Okay. You familiar with that? I mean, it's 3.9 acres that was approved about a year ago. So, I mean, it doesn't make sense to me how mine's too small and it's nearly twice as big. But is there any, specific questions that anybody would like to ask me? I mean, I've done everything that the county has asked me to do. And I feel like that, the paid professionals employed by the county, J.P. Madison, she put together a very, very nice speech about how the county should listen to them a few months ago. That was on a different subject, but...
Mr. Presley, J.P. Lundstrom has a question.
Yes, sir.
Yeah, I don't want to intentionally speak on this thing because there were comments being made here about that distance between the fence and the barn. I've never seen a survey, but there were people either in the Planning Commission or something here, and I don't remember just who was saying that it was less than.
No, sir. That's incorrect. There's surveys on in your county. I wish Nathan was here. He could back that up. I mean, I've presented that. They have it. County planning has that. They would not have recommended approval.
Well, that was one of my main complaints on the thing.
No, sir. I had a surveyor. I had to have a surveyor come down and actually survey it.
They kind of talk like they made that decision because it was grandfathered in. That building was already there when you bought it.
Yes, sir. That building was there.
And it had probably been put there before the county zoning was passed. I'm not sure.
Well, I mean, there's building setbacks in every, all the counties, all the cities have building setbacks. That's minimum standards. You can't, you can only build so close to property lines.
I know that. That's why I'm bringing this up. That was my problem.
And 10 feet, I think 10 feet is the county guidelines, and I'm beyond that. It's 17 point something feet on one side, and it's going to be 14 on the other. That's with the addition. And I proposed to building a privacy fence along that side. I mean, whatever we need to do to mitigate the noise or from the neighbors. But
okay.
I mean, a couple of times a week on a Saturday afternoon having a wedding, that doesn't seem like that's going to be detrimental to the neighbors.
Thank you, Mr. Presley. Your public time, your time is done.
I will ask you a question, sir.
It's past its 3-minute public comments. Okay, you can. Thank you, Mr. Presley.
I'm done. You can't go.
Yes, that's right. That's right. So public comments, anybody else public?
On most issues, if there's someone here that's involved in it, we usually let them speak at some time during the discussion. I don't think we gave Mr. Presley that opportunity until it became public comments.
Prior to, we did. But we did in that particular time. J.P. Ussery, go ahead. Any other public comments you can get ready to come. J.P. Ussery.
The reason that we're at the point we're at now is because so many neighbors complained. I strongly suggest that you be friends with those guys and get them to be on your side. That's why we're where we are.
Yes, sir. I understand.
And so that's something that would help all of us greatly. I mean, if y'all would sit down and y'all could get together and they could say, yeah, it's okay, we've worked it out. So we're asking you, please, if you could sit down with them and work that out. That'd be very appreciative.
There was a neighbor that showed up to Greenland Planning that was in favor of it. We had no idea she was coming. So there's neighbors in favor of it, but as we all know, they're not going to take time out. It's only the ones that are against it. And, I mean, somebody pointed out that these people are all against it. Well, I don't think that's true. I think there's just a few of them, and the other ones are here for something else. But,
Mr. Presley, we're going to ask, do we have any other public comments in regard to this? Thank you.
Yes, sir.
Any other public comments on this issue?
My name is Nancy Hartney. I live on Schaefer Road. I keep coming back to 3 points. The original zoning for that area says a cup can be permitted if it is compatible with the area. I think the constant presence of neighbors coming in, making comments, indicates it is not compatible with the area. The other point that I needed to, that I keep coming back to, is if this board, if you all can't make a decision, why do we meet? Why do we spend taxpayer money to have you here tonight? Mr. Landstrom, I think, concisely said that. It appears to me the other issue that keeps coming up and that plays in my mind a great deal are property rights. Let's look at the property rights of the people that are meeting the zoning requirements and that have been there for years and years and that contribute to that agricultural area. I thank you.
Thank you. Any other public comments? Any other public comments? Okay. We had JP.
A turn or was it just my
No, well, come on.
Hi, I'm Vicki Presley Hassel, and this was all my idea to begin this in the first place. And I wanted to point out about that there are other businesses down that road. I don't think that's been pointed out quite enough, that there are definitely other businesses down that road. There's I'm sorry, I'm gone blank. Right at the edge of the pavement, there's a trucking company there. And then the neighbor across the road from us has his own business where he is hauling heavy equipment in and out, down the road. And that's, every day that he's doing that, hauling heavy equipment. And we're right at the base of Drake Field. When they talk about the noise, there's airplanes several times throughout the day. We're just a few hundred yards away from the Arkansas-Missouri Railroad. There's that noise. So I just wanted to point out that there are, other things going on in that neighborhood other than just homes. And, we appreciate the homes there. And we have gotten along with our neighbors. We talked to Miss Lukens or Miss Bachman and Mr. Lukens, all the time. And, we are getting along with them. And we've tried our best to get along with the McDaniels across the road from us, but we have a hard time catching them at home. We are speaking to the neighbors, and we are getting along with them. So I just wanted to point out, a few things, and we will do everything, that's asked of us in the future to continue getting along with them. We just want to have a good family business in Washington County to, help generate more income for Washington County. It won't be just us, producing tax money. It will be people coming in from out of town, staying at our hotels, eating at our restaurants, shopping at our stores. So, it will be producing more money than just from us. We just want to have a good, wholesome family business in Washington County. And we hope that, you will see it that way. Thank you.
Thank you. Any other public comments? Okay, we have a motion to pass the CUP by J.P. Harbison, a second by J.P. Pond. We'll go with Ms. Patty on the roll call. Pardon me?
Oh, I need to read it, yes. I'm
okay.
Sorry. An emergency ordinance ratifying a conditional use permit granted by the Planning and Zoning Board.
Go ahead, Ms. Patty.
Ann Harbison.
Yes.
Joe Kicklack.
Yes.
Tom Lundstrom.
I'm going to abstain because my son has built a wedding chapel.
Eva Madison.
No.
Sue Madison.
No.
Joel Maxwell.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Usry.
Yes.
Daniel Balls.
No.
Harvey Bowman.
No.
Alicia Devins.
Abstain.
Robert Dennis.
Yes.
Lisa Ecke.
Yes.
All right, does not pass. The appeal will continue. Item number 12, J.P. Harbison. I mean, that was 11.
Hold on. There's a question.
I have the question. So
JP.
Two abstentions. Are they coming out as a no vote?
Yes, sir.
Why call them abstain?
You have the vote it's an affirmative vote to pass, and to do so you have to have the majority in that, and so an abstention is a no vote. It's not an abstention can't be an affirmative vote for whatever's being voted.
Well, we had one JP said that he was abstaining because he has a wedding venue. Would that not disqualify his no vote as well?
No, it's counted as a no vote because it's not voting affirmatively for the motion that's on the table.
So So there were 7 yeses and 5 noes.
7 noes.
7 noes, yeah, 7 noes.
7 and 7. And it
7
requires,
7.
And it requires a majority.
It's actually required.
It required 10, yeah, because it's an emergency. So it requires a super majority.
Okay, J.P. Dennis. J.P. Harbison.
Okay, resolution supporting the construction of a playground at the Brentwood Community Park and rest area. I move that we pass 11.1. Second.
It's been moved and properly second. This is a roll call. Any comments, questions? Any public comments? J.P. Balls? Resolution. Okay. You want to read the resolution? By title.
A resolution supporting the construction of a playground at the Brentwood Community Park and rest area.
Any other comments? J.P. Madison.
Thank you, Mr. Judge. I fully support this resolution. The community down there has worked long and hard to retain that park, but I would like to ask our staff in the future to try, even in this era of relaxed standards, to use good grammar. Thank you.
Any J.P. Dennis?
Well, I'm deeply concerned about the noise level out of a playground and how that'll disrupt the neighbors that live next to it. What have we done to ensure that those neighbors are protected before we do this?
J.P.
I'll be voting no on this resolution.
Well, since they're at least a quarter of a mile away on each one of them, I don't think, the noise level will not be a problem. Sorry.
I'm an expert. I have 15 grandchildren, and I know how much noise they can make. I will not vote for this or spend money on this until we know that those neighbors are well protected.
Public comment. Oh, J.P. Pine.
I have hopes that I could change your mind on this, Mr. Dennis. And you may be coming before us sometime and have to abstain for a vote when you decide to put up a wedding venue.
That could be true. I think wedding venues are a nice thing.
Public comments. Any public comments? Ms. Patty, roll call.
Ann Harbison,
Yes.
Joe Kicklack,
Yes.
Tom Lundstrom,
Yes.
Eva Madison,
Yes.
Sue Madison,
Yes.
Joel Maxwell, Joe Patterson, Butch Pond,
Yes.
Bill Ussery,
Yes.
Joel Maxwell,
Yes.
Daniel Balls,
Yes.
Harvey Bowman,
Yes.
Alicia Devins,
Yes.
Robert Dennis,
Yes.
Lisa Ecke,
We're good? Okay, J.P. Harbison. 12, item 12.
12, an emergency ordinance ratifying conditional use permit granted by the Planning and Zoning Board. This is a Dorman Trust. There was some issues with property lines, and they have corrected those. So I think that was, if I remember when I read this a couple of weeks ago. So I move that we pass this.
It's been moved by J.P. Harbison, second by J.P. Madison. Any comments? Any comments? She read. Public comments. Any public comments? It's already done. She read it.
She read it.
Go ahead, Miss Patty.
Ann Harbison,
Yes.
Joe Kicklack,
Yes.
Tom Lundstrom,
Abstain.
Eva Madison,
Yes.
Sue Madison,
Yes.
Joel Maxwell,
Yes.
Joe Patterson, Butch Pond,
Yes.
Bill Ussery,
Yes.
Daniel Balls,
Yes.
Harvey Bowman, Alicia Devins,
Yes.
Robert Dennis, Lisa Ecke.
All right. J.P. Ecke, item 13.
Thank you, Judge. This is something that passed unanimously out of the Personnel Committee, and we're simply just changing the name, the title of a position that's already been budgeted and approved. So if you would, Mr. Lester.
An ordinance changing the title of Education Coordinator to Assistant Enforcement Officer in the Environmental Affairs budget for 2018.
I make a motion to pass.
It's been moved by J.P. Ecke, seconded by J.P. Madison. Any comments? Any comments? Public comments? Any public comments? All right, Ms. Patty.
Ann Harbison,
Yes.
Joe Kicklat,
Yes.
Tom Lundstrom,
Yes.
Eva Madison,
Yes.
Sue Madison, Joel Maxwell, Joe Patterson, Butch Pond, Bill Usry, Daniel Balls, Harvey Bowman, Alicia Devins, Robert Dennis, Lisa Ecke.
Yes.
All right. J.P. Ecke, item 14.
14.1, this also passed unanimously out of the Personnel Committee. It's a title change in the IT department. If you would, Mr. Lester, please.
An ordinance changing the title of Computer Software Design Technician in the Information Technology budget for 2018.
I move to pass.
It's been moved by J.P. Ecke, seconded by J.P. Madison. Any comments? You had a comment? J.P. Madison.
Is it stay the same grade? Because it's reflected that it's grade 18 currently. I was curious.
I can't remember. Was that the same? Did he leave? He just walked out.
Is Mr. Watson here?
I think it was just the title.
It's within the margin. It did change
The grade?
the grade, but it was within the margin.
The range.
Range, I'm sorry, within the range. And the budgetary needs were already there that had been approved.
Is it going up or down in grade?
It's going up a grade.
Thanks.
Thank you.
Any other comments? Any public comments? Any public comments? Ms. Patty?
Ann Harbison, Joe Kicklat,
Yes.
Tom Lundstrom,
Yes.
Eva Madison, Sue Madison, Joel Maxwell,
Yes.
Joe Patterson, Butch Pond, Bill Usry, Daniel Balls, Harvey Bowman, Alicia Devins, Robert Dennis, Lisa Ecke.
Okay. You good, Ms. Patty? You okay? All right, item 15, J.P. Ussery.
Thank you very much. This is appropriating some additional funds to the Sheriff's Department to get the airplane engine fixed. And the money's there. It's just we're moving it from one account to another account. And it's to, like I said, it's to finish getting the airplane engine overhauled. It had to be overhauled, and the first quote they got, the guy went out of business. And so that's why this is a little bit higher price. But this should get them back in the air again once we get this done. So would you mind reading this, please, Mr. Lester?
There's no ordinance on this. This is just you have to approve by voice vote the transfer because of the amount.
Use that motion. Got a motion by J.P. Maxwell, second by J.P. Patterson. All in favor? Aye. Those opposed? Okay. J.P. Ussery, item 16.
Thank you very much. Item 16 is... did I go too far? Oh, okay. I'm sorry. Okay. Sorry. Would you read that for us, please, Mr. Lester?
An ordinance appropriating the amount of $7,854 from the Communications Fund 3014 to the Communications budget for 2018.
And so this is just simply moving some money for the communications. And so I move that this be passed as...
All right, got a motion by J.P. Ussery, seconded by J.P. Ecke. Comments? Go ahead, J.P. Ecke.
Judge, I don't have a comment on it, but I do have a question. Could the author clarify a little bit more about the transfer?
Is he here?
The appropriation.
Mr. Hoyt?
This is a John Luther.
No,
Yeah,
this is Sheriff.
Or it's a sheriff.
Which one?
I don't know what the question was, but you were looking back that direction. I'm Rick Hoyt with the Sheriff's Office, and I can't hear a thing back there.
Was it on the?
This is 16.1, correct? The communications transfer?
No, it's
I don't
not.
think
You didn't have a
That's
question?
not. Okay, that's not you, Hoyt.
Thank you for
I
your
thought that was
service
Sheriff.
as always, though.
Appreciate you.
Sorry, just a moment.
Was that? He's not
That's
here.
the aircraft engine.
Yes, that's coming out of the sheriff's.
It doesn't require this.
No, that's not the one.
It is.
It's not you, Chief. No, it's Rick. It's Officer Hoyt.
We're talking about the airplane?
Yeah, it is. It's the airplane.
We moved the money from communications to.
Is that where you
That's
want to
it.
move the money?
Yes.
Okay, now I understand.
Okay.
Okay, and
That's
I
you.
apologize. I didn't think
And
of
it's you.
it.
Where you want
I didn't realize it was two different places. I'm sorry.
Just show me the money.
Yes. The money is in the communications fund.
That's correct. And you
Okay, and we're
transferring it.
moving that money into the communications budget to help further this airplane engine replacement.
That's correct. Did it help you?
That answers my question.
Thank you, sir.
Thank you.
We got a motion. We got a second. Motion by J.P. Maxwell, second by J.P. Madison. So that's an ordinance. So any comments? Any other comments? Any public comments? Any public comments? All right, Miss Patty.
Ann Harbison. Joe Kicklack. Tom Lundstrom. Eva Madison. Sue Madison. Joel Maxwell.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Usry.
Yes.
Daniel Balls.
Yes.
Harvey Bowman.
Yes.
Alicia Devins.
Yes.
Robert Dennis. Lisa Ecke.
Yes.
All right. J.P. Usry, item 17.
Okay, and I apologize for the last one. I didn't realize it was in two pieces.
Yep.
So I was so focused on this particular one on the $15,000. This is a $15,000 grant that we were able to get, and it is to upgrade our security system. And the way this works is that this is a grant that each year we're able to apply for. And so what the plan is to take this $15,000 and start that process. And then next year we're going to apply for the grant and hopefully get the remaining. I believe it's going to cost about $32,000 to complete the project. But the plan is to use this money to start that project, and then next year we're going to apply for it again, hopefully get enough money to finish. And this will greatly improve the security of the buildings. And so would you read this for us, please, Mr. Lester?
An ordinance anticipating revenues totaling $15,000 in the court security fund and appropriating $15,000 from the court security fund to the court security small equipment line item budget for 2018.
Who was that?
And I move that it be passed as read.
We got a motion by J.P. Usry, a second by J.P. Ecke. Comments? J.P. Madison?
So I'm going to actually vote against this, and I'm going to tell you why. So I have gone back through all of our agendas. There was never a resolution authorizing the application for this grant, which has been quorum court procedure for as long as I can remember and as long as a lot of other people can remember. We always authorize grant applications, and we did not do it with this one. So I think there is a procedural irregularity with it coming to us this way. The second issue is that I have talked to county employees about the current security we have. All employees are currently issued ID badges. They have them on their persons. It's up to the elected officials whether they require them to wear them, because some of the offices, if you go in, you'll see that they have name badges. Like if you go into the county clerk's office or the circuit clerk's office, they wear a nameplate that says, Eva Madison, quorum court member. And so they opt not to also require them to wear an ID badge. And I'm not totally sure about how it would work to force other people that work in the courthouse, especially state employees, to wear something else other than what their elected official told them to do. But right now they have picture ID and they have the key fob that we all have that they must scan if they come into any other entrance but the main one, and they must scan when they go out of any other entrance other than the main one. And so I don't know how this is a good expenditure of anybody's money, regardless of whether it's technically free money to the county, because it seems to be a duplication of what we already have. And given that it's going to cost $27,000 more money, $22,000 more than what we're getting, and we're just going to hope for more, that's why resolutions come to us before we apply for a grant, so we know how it works. Because had this come to us and been explained that we're only getting a little bit of money and it would cost a lot more, we might have thought differently about whether to go through with that. And certainly it's better to ask for permission than forgiveness. But given the security we already have, it is not at all apparent to me that we need to spend $37,000 additional dollars to supposedly improve what it seems like we already have. So I'll be voting against this, and I think we should give this back to whoever gave it to us and let it go to a courthouse that doesn't have anything.
All right, J.P. Madison, J.P. Pine.
I'll be voting for this, and sometimes we don't realize the need for security, for safety issues, for just keeping account who comes and goes in this courthouse, even through the front door. And what keeps coming to mind, and this may sound so ridiculous, but in this day and time, you grow to understand the necessity. What comes to mind, there is a parts house in Springdale, Arkansas, and I'm not going to name the name. I frequent the place. I'm there quite often for parts for antique farm machinery. But it's like a 2-room building, not counting the men's room and the women's room, which are in the back of that building. I'm very welcome to go to the back of that building to use the men's room, but I have to log in before I go back there in this 2-room building for insurance reasons. So they know who's back there. So the insurance company knows. So the liability covers. This is just things that are necessary this day and time, particularly in a building this size, a public building owned by the public, supported by the taxpayers. It's something we're going to have to live with, whether we're comfortable with it or not. And I will be supporting it. I appreciate that they're taking so much time to get these grants to do something that sometime this will be complete when we already needed it 2 or 3, 4, 5 years ago. Thank you.
J.P. Maxwell and then J.P. Harbison. Thank you, J.P. Pine.
Thank you, Judge.
I'm sorry, J.P. Madison, then J.P. Maxwell.
Hey, after that last comment about age before beauty, I'm done.
Be careful, you do sit next to me. Thank you, Mr. Judge. I am all in favor of additional security. I'm just not convinced that name badges are the way to accomplish extra security. And I would like to point out that I'm not sure where I would attach a name badge to this dress. I don't spend a lot of money on clothes, as you all may have noticed. I wear the same things over and over and over again, and I wouldn't want to stick a pin or one of those clippy things on this kind of delicate dress. Are they going to be magnet attached? How are they going to attach? I'm not sure that the ladies in the courthouse are going to rush to this name tag issue because of the way we dress. But I certainly would like to see us spend money on security, as I would like for our schools to spend money on security. Thank you.
Thank you, J.P. Madison. J.P. Maxwell.
Thank you, Judge. I think I still just have some questions. I'm not real clear on what additional security benefits or whatever this brings. I know what we have now to some degree, and so I don't know if there's anyone here that could speak to this or that's been working on this to just kind of help us understand what improvements, not necessarily what equipment we're going to purchase or what the system's going to look like that's different, but what the value or the benefit would be. Is there someone here that...
I asked the county attorney.
Okay, perfect. Thank you.
So we got to looking at and this was the judge's office has had conversations, not necessarily with the sheriff, but we have talked to the local security officers about some possible upgrades. One problem we have right now is our system, when people come in and out, while it tracks ingress, it'll tell us who comes in, it does not track egress. We do not know when people come out of the building. The issue with the name tags and the photo IDs is purely a security issue, so that security and other employees will know who is an employee and who is not. In addition, visitors will also know who is employed. There's numerous times a day that I am in the building that I help somebody who is clearly lost. A lot of times they're down on the first floor. So these were just some ideas that we circulated on changing. We have fobs. They were given out like candy. We have a list of hundreds and hundreds of people, whether they worked for the county, whether they were just a private citizen, whether they worked in law enforcement, and there's no rhyme or reason to these fobs that have been given out over time. Literally, it was astonishing to see who all had fobs. We had a problem with that, where a former district judge who had a fob brought his criminal client in through the first floor and up to criminal court on the fourth floor, and that's an issue. We also have a problem when we have employees who either leave, retire, quit, or are terminated. A lot of times security doesn't know the face with who these people are, and so we don't have a way of saying, hey, if you see this person, they're no longer an employee. These are just some small issues, some things that we are trying to address with these badges. The county judge is responsible for security of all grounds and buildings of the county, period. That decision rests solely with him. You are, just as you are responsible for all appropriations and money that's spent in the county. There are some grants that require resolutions, and we get those resolutions for those grants. I've yet to find, and if J.P. Madison can point me in the right direction of the law, that states that every grant application requires a resolution. If that's the case, that's fine, but we're going to miss out on grants because sometimes these grants are time sensitive and we don't have time to call a special quorum court meeting or come to the quorum court to say, hey, will you give us permission to ask for free money? It seems kind of ridiculous to think we would even do that. The issue as far as the name badges, yes, as a county employee, as anybody that works in this building, if you want that access where you don't have to go through security, you will abide by the county rules, whether you're a state employee or not. And if the state employees or certain elected officials don't want their employees to have to wear them, then they won't have that access to the building. They can go through security, just like the general public does when they come in. These are things that we're doing to looking for safety for our employees as well as other people in the building. And so these were some of the ideas that we came up with. This $15,000 does not require, this money doesn't require us to put anything down or implement so much of this by so long. We have a year to spend the money, and we can ask for money again every year, which we've done in the past. The maximum you can get a year is $15,000. It is rare that the AOC gives out the maximum amount. But with our program and what we submitted, we were the only county that got the full $15,000 awarded that was requested this year. So that's what we're looking at.
I remember, obviously. Go ahead, JP. Lundstrom and then JP Maxwell.
Yeah, was that just some follow-up questions and keeping the floor there? Will changing out these ID cards be less expensive than changing out fobs or reclaiming fobs from ex-employees or whatever? I mean, we can deactivate fobs now, but in theory, every time I've had a fob like this, part of your employment termination, whenever you do exit, is you have to hand that property back to your employer. So I'm assuming we intend to do that. I don't know how often that happens, or if we lose those fobs and there's actually some cost savings to having something that's easily reproduced instead of reclaimed.
We do have that policy that the fob has to be returned. And so we have the employee return the fob. We have other individuals who are not county employees who have fobs.
Can we deactivate those fobs?
We can. And so, for example, I know one of the big lists we have is Fayetteville PD. Has a lot of Fayetteville PD officers have fobs for our building. We have no way, as the county, of knowing if these people are still employed by Fayetteville. And to be real honest, if you don't, a lot of people, if you're like me, you have a fob. If you don't end up turning it in, it ends up in a drawer somewhere. And 2 months down the road, you're going, what is that and what is it from? I've got tons of keys that I have no idea what they go to. So I know that this happens. We can deactivate those, yes, but we're talking about an upgrade to the actual system itself. And so the ID badges, and it's similar to, you can see Rick back there at the sheriff's office, they require every one of their employees who is not in uniform, I believe, to have and that's an ACIC, NCIC rule, that have an actual photo ID badge on them worn at all times. So every one of their employees has to have that. So I don't think that the having it is an issue, because we already have some county some personnel that do it. I have one right here for when I go down there for the same reason. I'm technically not employed under the county sheriff, but I have to abide by his rules when I'm in his building. And so, which is, anyway, the judge is the same way. We all have these badges in order for us to go down there and be able to walk into their building unaccompanied. So, yes, we can deactivate those, and sure, the fob, the badges are a little bit more. The ID badges that we currently have in the system that makes them is very, very, very old. I'm talking about old Windows old. There's not a lot of change. We can't redo. As you see, the sheriff, they have really nice professional-looking badges. Our county badges are terrible. The pictures are tiny. You can't see somebody's face. They serve no real purpose in identifying anybody, and no one's required to actually ever have them on them. Some staff I know, some places, I know Judge Zimmerman down in juvenile court, for example, requires all of her people to wear their badge. And they're a sideways badge, so they wear their badge like this, and the face is sideways, and you can't see it, and you can't even see what it says. So this system will completely redo that, where we can redo these badges. We can buy the RFID chips on the badges, so there's a dual purpose, both in an ID. We can design them, put the bigger picture and the information about who they work for, where they work in the courthouse, and it's very noticeable and easily recognizable from other employees in security.
Two quick questions to go with it. Is this $15,000 grant, does this have the potential to be a recurring grant if we apply for it each year?
That's correct.
Okay. And then secondly, will the technology in these badges, is one of the things we intend to do with that is have some sort of scanner or awareness in the system where at any moment all the people in the building with that badge? Do the key fobs now don't have that?
That's correct. That's correct. And I'll tell you, in just a plan overview, look at the plan and talking with our security personnel here, who are great, by the way. The one big issue we have with this building is we have downstairs on the first floor where people come in, and we have a policy where you can't piggyback. We don't have anybody down there, anybody watching the building at all times to ensure that there's not piggybacking. And I know that, as an employee, new people show up, and you don't want to be the jerk that says, "Oh, sorry, I'm going to shut the door, and you're going to have to use your fob." I get it. With new people, it's difficult. So one of the things that we've talked about is the possibility of actually having somebody down on a security member down on the first floor when we talk about moving Judge Taylor over, and we have these excess security personnel. That may be something we look into. There's no plan that's been made, but that's certainly been a discussion of, would it be beneficial to have somebody down there that's actually checking the IDs and the people coming in, and ensuring that we don't have anybody that's shouldn't be coming in. We give these fobs out to like part-time law clerks that change, each semester. I mean, there's a lot of things that we do that makes it really hard for our IT to track all these things because of the amount of turnover we have. This is going to hopefully help with that turnover on making sure that we are keeping our building secure at all times.
Thanks, Judge.
Thanks. J.P. Lunsford.
I have a question and a comment. These badges that you're talking about won't open that bottom door like the fob will, right? That's why you would have to have a security guard down there.
No, it will.
It will.
It'll replace the fob. It becomes the fob.
Well, see, a fob or a card doesn't create security.
True.
I don't know how many times I've been let in that bottom door by people who don't know me from Adam.
That's exactly right.
So it takes a lot of training of county personnel to make sure that does not occur. I don't care whether people are upset or not because they get the door shut in their face. They don't come in unless they've got a fob, period, or the card that will let you in. You know, I made this comment last time I was here. Eva gave me a hard time over it because this guy come in with a whole two-wheeler full of stuff that wasn't x-rayed. Security is security. You know, in the military, the security we provided when I was in the Marine Corps, you know, if you was in there fooling around those planes and didn't do what you was told, you were probably going to be dead. Security is something that's very vital, and it's getting more and more vital every day with all these people we have out here now, which just like to blow up courthouses and police stations and so forth. So whichever method we use, whether it's the card or the fob, we need extremely good training, personnel training, on how to use these and what's expected of them. And if they don't do it, they need to be fired right there and then to let everybody else know this is what you better do. So that's my comment, Mr. Chair. Thank you.
Thank you, J.P. Lundstrom. J.P. Keeklak.
Someone else on the floor.
Okay.
Go ahead.
You're on the roll.
Thank you. Thank you for no comments. I wanted to ask our attorney some questions.
Who made the motion? Right here?
Come on, go ahead.
Is he listening?
Keeklak, J.P. Keeklak. All right, go ahead, J.P. Madison.
Attorney Lester,
Yes, sorry.
would you consult with the ladies at the courthouse about the design of the badges and maybe put them on a string like Major Hoyt's rather than the clippy thing that makes a hole? But
I think our intent is to offer whatever is most convenient for people and have options. I mean, so that if you want the stringy clip, great. If you want the lanyard, we'll take care of people.
well, let me ask this. I mean, it should be fairly easy to turn off the fobs because I lost my keys about 2 years ago and immediately went to Ron Wood and he deactivated it. I did find them. I don't think I've reactivated it, but maybe we could charge a deposit on these things. You know, if you knew you were going to get $100 back when you turned in your fob, you'd probably turn it in. And if they're just knocking around a drawer somewhere, I have enough clutter at my house. I don't need a drawer full of fobs. So I agree with J.P. Lundstrom that I think extra security at the courthouse is a wise preventive move, and the more we can do about training employees that you don't let every Tom, Dick, and Harry come in with you is good, and I'm glad we're thinking ahead for these kind of issues. Thank you.
Thank you, J.P. Madison, J.P. Keeklak, and then J.P. Ecke.
Thank you, Judge. What's the total cost of the project that you have in mind?
Was it 30? Oh, no, 30, 37.
Okay. And when do you plan to implement the project?
Starting whenever we start getting grant money. So we have a year to use the first $15,000. They'll apply again.
And the funds in excess of the grant money, you have them in the budget line item that are being unused currently, or did you budget for a security upgrade?
We already have a security line. I can't tell you how much is in it, but we do already have a security line. So this is a grant, no matching, that the Office of the Courts, that was probably 2 months ago when Justice Kemp and them were here, and they said, please apply for these things because we got monies we want to upgrade our systems on all the courts, and so we did.
Okay. But do you have money budgeted for this project this year that you budgeted last year?
I can't tell you how much is in the line.
I'm not asking how much is in the line. I'm asking, do you have money budgeted for this project this year? And you intend to do the project this year?
Yes.
But you don't know if you have money budgeted for it this year?
I can't tell you how much.
I'm not asking how much. I'm asking, do you have money budgeted for it this year?
This project came up as a result. The project was created as a result of Justice Kemp saying, "Hey, you need to apply for this grant." So we created a project. We looked at what it would cost. Right. There's no requirement that it all be done at one time. So in order to get money, you have to have a plan. So we have a plan. We're not claiming. No one here is claiming that we're going to. That at any point, anybody's coming back and saying, "Hey, Quorum Court, we're going to need more money." We're going to utilize the money we have and then and hope to either have, we'll put it together as it goes along, however we can afford it.
Okay. So yeah, I'm not claiming or arguing for or against any point here. I'm just asking about the budget because the Quorum Court's responsibility is to be a guardian of the fisc. So I want to know how much money we intend to spend on this project, and if we had the money budgeted this year.
No.
So we don't have a budget this year. So you intend to do the upgrades next year if we get the grant.
We had planned on doing it part. I'm going to try to explain this a lot easier. So they give us.
I'm really sorry. I'll let the judge to answer my question.
Okay.
Well, it's the same. If we get, whenever the grant comes in, then that's when we'll start working on the project. We'll work the project until we get through whatever that $15,000, and then we will stop until we get a chance to apply again for the remaining.
Oh, okay. Great. Thank you.
Okay. J.P. Ecke.
When in doubt, just take it from the appeals attorney that we're hiring, and perhaps we'll have money then, because we tend to have money for things that we want, but not what we need. Enough of a public comment on that. I know that I have a contract with Cargill, and they require the same thing because of the current environment we all live in today, and they are a worldwide food source, as is Tyson, as is George's, and other areas. They all have this, and it gives you access to the parking lot, and you better have it. That's where you get in, and you better have it, and it keeps them accountable to who is in the building at all times. Visitors are marked by, they have to fill out their forms, even if they're going to the men's room, hopefully. A visitor's badge, but they have to turn in their driver's license and can't get out until they give back their driver's license when they give back the visitor's badge. I'm in favor of this because I value the employees and people here in this courthouse, and if anything were to happen, the unimaginable, and we were able to account for people because who has this, who was in here, and who was not, is going to be valuable information. I used to work for an airline, same thing. This is what we went through, and you better have your ID that marks you as you belong here, you're an employee. So I'm supporting this, and I'd like to close discussion and vote.
J.B. Harbison, you had anything? No? Okay. All right. J.P. Balls. All right. You call. So we had a motion by who made the motion?
Bill Ussery.
J.P. Ussery, seconded by J.P. Ecke. Any other comments? Public comments? Any public comments? All right, Miss Patty.
Ann Harbison.
Yes.
Joe Kiklak.
Yes.
Tom Lundstrom.
No.
Eva Madison.
No.
Sue Madison.
Yes.
Joel Maxwell.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Ussery.
Yes.
Daniel Balls.
Yes.
Harvey Bowman.
Yes.
Alicia Devins.
Yes.
Robert Dennis.
Yes.
Lisa Ecke.
Yes.
Okay, J.P. Ussery, item 18.
Okay, this is the Rural Grant Fund, and this is to help pave a road that is, the runoff goes into a water source, ultimate water source on the Illinois River. And what we did is last year we got one of these, and we did it on in kind of the center to the east part of the county. This is for the west part of the county. And so this is to help us upgrade the road, to pave the road. And so I move that if you'll read this for us first, Mr. Lester.
An ordinance recognizing the amount of $75,000 in the Rural Community Grant Fund for 2018 and appropriating the amount of $75,000 to various line items in the Rural Community Grant budget for 2018.
Move to pass 18.1.
We got a motion by J.P. Maxwell, second by J.P. Pond. Any comments? Any comments? Public comments? Any public comments? Miss Patty.
Ann Harbison.
Yes.
Joe Kiklak.
Yes.
Tom Lundstrom.
Yes.
Eva Madison.
Yes.
Sue Madison.
Yes.
Joe Maxwell.
Yes.
Butch Pond.
Yes.
Bill Usry.
Yes.
Daniel Balls. Harvey Bowman.
Yes.
Alicia Devins. Robert Dennis. Lisa Ecke.
All righty. J.P. Madison, item 19.
So I had asked this be put on the agenda, and it passed out of county services to be put on the agenda because we were not consulted in any way on the native flower decision and whether to appeal. And I had prepared a resolution tonight for consideration that was the best way I could figure out to undo this, because to give you all just a tiny bit of background, the native flower marijuana decision that this court turned down was appealed to circuit court on December 21st, 2017. The two named parties in the case were the county and us as the quorum court. I don't know about you all, but I learned about the fact that the case had been filed from the newspaper. I didn't find out from the anyone in the county judge's office, or because I was formally served with any kind of notice of the lawsuit. So how that all happened sort of remains a bit of a mystery. But the case proceeded, and the judge, much like in the wedding venue appeal, granted summary judgment in favor of the applicant on April 4th, 2018. Despite the fact that the quorum court was a party to that decision, we were not informed of the decision, and it was only because Ms. Sims researched the case, because it was kind of on her list, that she saw a decision had been entered, and there was an article in the paper about it. And I think that is how most of us learned that the court had issued a decision. And by that time, by the time we learned about it and were able to first discuss it at county services, the appeal time had passed. So all of those discussions that we had about whether to appeal the wedding venue, we could not do because the time had passed, because we had not been informed of the court's decision. So after we all discussed that and county services moved to put it on the agenda for discussion tonight, not really sure at that point what our options were if the time had expired, Judge Wood sent us a letter saying that he alone made the decision not to appeal. And I say that I'm disturbed by that decision, and I mean to use the word disturbed. The quorum court was a party to that case. It was an appeal of our decision, and the judge proceeded to make a decision on whether to appeal it without consulting us. So what I had done in trying to figure out a lawyerly way to navigate this was basically that we would have to beg the judge in the case to vacate his decision and re-enter it so that we could have a new time to properly appeal, since we had not been informed of it. So I had prepared a resolution to do just that, outlining the sequence of events that we had not been informed of it. But the Supreme Court made a decision today and changed all of that. And so the resolution that I worked on was for nothing. The Supreme Court today rejected the appeal by the unsuccessful applicants. I don't believe it was native flower, but it was the naturalists, something that sounds like native flower. So there were some other, I think most people know this, but there were some other unsuccessful applicants that had sued in circuit court in Pulaski County to challenge the commission's decision-making on who was granted the growing permits. Native flower didn't get one, and so it seemed like it was sort of a non-issue. But then when a judge in Little Rock reversed those decisions and they seemed to be back in play, like maybe native flower could get one, maybe we would have a marijuana facility in Washington County, it looked like, well, maybe the court should decide to appeal because there's something at stake here. But the Supreme Court today reversed that decision and said that the judge in Little Rock lacked subject matter jurisdiction to make the decision. I read the decision. Doesn't look to me like there's much hope of there being any way for native flower to somehow emerge from all of this. I would say that I don't think the marijuana applicants are quite done with fighting, but based on the Supreme Court's decision, it didn't look like there was anything to do. But I will say that I will make it very clear, my opinion is, if we are a party to a case, we should be informed of what happens in that case, and we should make a decision on whether to appeal, period. We're the legislative branch. We're not the executive branch. We need to make our own appeal decisions, just like we have really stewed over with respect to the appeal of the wedding chapel. So I don't know that there's any more to say. I'll spare you all from having to vote on a resolution thanks to the Supreme Court's very timely decision today. So thank you, Judge.
Thank you, J.P. Madison. J.P. Balls.
Thank you, Judge. I agree with J.P. Madison 100% there. I think that we should have been told about this. We made that decision on that. I was kind of shocked when I read it in the paper, and then I went back to my emails to see if I'd had anything. Hadn't heard about it. We hadn't talked about it. And I would just ask that when these situations come up, if we could be informed going forward. At the end of the day, I don't feel like it was your decision by yourself to make that. We get to make those decisions, and I'm just asking going forward, Brian, don't shake your head at me like that.
I thought you were talking to me. All right. I hear you.
I'm just asking that going forward, if you could be a little more communicative with us when these situations come up, just to avoid these issues going forward. I appreciate it, Judge. Thank you, sir.
Thank you, J.P. Balls. Any other comments? Committee reports. We'll start right around J.P. Bowman. J.P. Dennis.
We met, we met, and Larry Shackelford from Washington County, Washington Regional Medical Center came. He's the new CEO, and gave us an excellent presentation about Washington Regional. We had the motion on native flower, the cup appeal, and that was Eva Madison, and we just heard that. We also discussed the planning department, and we talked about fees, whether or not we needed to raise fees or not raise fees, or exactly where we stood. And we didn't have any motions, but we had discussion on it. And so I got some information concerning that from Chief Gales. And so far this year, planning department has spent $313,499 to make all these decisions that they've made. And we've taken in on fees $11,264. So in the business world, that's not a real profitable situation, but at the same time, they are there to make decisions for the county and keep, it's a service, and it's also a regulatory organization as well. So that was our committee report. Thank you.
And J.P. Ecke.
Yes, sir. The Personnel Committee did meet, and we discussed the title changes of the two positions that was passed unanimously and voted on today. And we also talked about the employee handbook, and for all, I believe that it was emailed to all Quorum Court members for review. And I asked that everybody make notes on their yellow pad to save the county money and review the handbook. So that way we can, it's very close to adoption, but it's completed. It's been updated, and that's it. So thank you.
Thank you, J.P. Ecke. J.P. Maxwell.
Thank you, Judge. Jail and law enforcement met. The main topic of discussion was just the fact that as Washington County grows, so does our need for more jail space, particularly the fact that Springdale intends to close their jail, and we'll be bearing the additional value of that, so we discussed that. Also, we are currently overcrowded. I think it's probably an understatement. Our gentlemen are back there right now. They might agree with me. We have around 658 in a 710-bed jail, but those are not always apportioned. They don't always commit crimes according to the beds and the designations we have, so we have several sleeping on the floor right now and making do. So just trying to make sure we understand where we are with that and what the pressure is on the jail for that. And then we have an ongoing issue of trying to manage the pretrial detainees, because those are, number one, we pay the 100% of their expenses from intake until conviction. Even if they're a state or a federal prisoner, when we eventually get reimbursed for them, we pay the full price until that conviction comes through. So that continues to be a problem, partially on funding, but also on the overcrowding. So we're still working through we're getting better at that percentages wise. sometimes it's hard to see because the numbers at the jail are larger than they were 4 or 5 years ago. So it stands to reason that the folks that would be there pre-trial are also, there's more of those. But statistically, we're not out of line. We still just a problem we have to deal with, and it is getting bigger just due to the nature of more people in jail. And then the last thing we discussed, Judge Zimmerman came in and gave us a little bit of an understanding of the timelines and the processes of how we would acquire an additional judge for Washington County, additional circuit judge. As our population grows, so does our need for all of these services, but that is all managed and handled by the state. So we're in the process of making our case for our growth and our need for doing that. So she walked us kind of through when that would be a possibility and what that process would look like. Thank you, Judge.
Good job. Thank you, J.P. Maxwell. J.P. Usry.
The Budget and Finance Committee did meet. We discussed the items that we approved tonight. The other thing that we kind of got off track a little bit, and we also talked about the pretrial a little bit, and we have several things we're looking into. And then we talked a little bit about the upcoming budget and some things that we're working on with the state to see if we can be reimbursed a little bit more for the prisoners that we hold for the state. And so that's kind of an ongoing issue that we're working on, and that was it.
All right. Other business. J.P. Harbison.
How many pretrial prisoners do we have today?
Usually about 375.
375, so we're up 30. It was 340 last week.
Any other comments? J.P. Maxwell, other business.
I guess this goes into other business. I had the opportunity today to be out in Morrow, Arkansas, and that was a road project that was brought to Chief Gales and yourself, where there was a road that had gained a lot more usage over the last couple of years, and with the development out there, we'll get a whole lot more usage. And so Chief Gales put that on the agenda, and there's a very nice chip and seal road that far exceeded their expectations, both in how much of it you were able to do for them and the quality of it. So all of the gentlemen on the board at Teen Challenge have a signed thank you note for you, so I'll present that to you and Chief Gales here in a moment.
Excellent. Thank you. Teen Challenge is a great organization there. Any other business? Thank you. I do want to say thank you again, J.P. Lundstrom, for last month, but we had a couple of graduations, and so appreciate you stepping up. High school and college. One college,
but that's
one high
why
school.
Everybody knows who he is, whether he knows who they are. Everybody knows who he is coming in the door.
Appreciate you guys again. Thanks again for the citizens being here. Need a motion?
Motion to adjourn. Second.
Motion second and meeting adjourned.